Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, good afternoon, everybody. Welcome to the Fourth Circuit. We have 3 cases on the calendar this afternoon. Before we get started, I want to acknowledge and thank the Honorable Thomas T. Cullen, United States District Judge from the Western District of Virginia, for joining us this afternoon. Welcome, Judge Cullen. We're glad to have you.
Thank you for having me.
All right, the first case on the docket is 20-2001 Western World Insurance Group versus Church Mutual Insurance Company. And Ms. Tillman, we'll hear from you.
Thank you, Your Honor, and good afternoon. I'm Ainsley Tillman, and I'm here with my colleague, Ian Ford, on behalf of the appellant, Church Mutual Insurance Company. We would like to reserve 7 minutes of our time for rebuttal. May it please the court. $2 million. $2 million, that's how much money was available to the refuge by virtue of its direct insurance policies with Western World and Guide One. That $2 million in available insurance proceeds was sufficient and more than adequate to completely cover the refuge for the loss that it sustained when the church property that secured its mortgage was set on fire. Because the refuge had a complete remedy at law, the district court was wrong to fashion a remedy in equity. I'm here today to answer this court's questions and to urge it to find that the district court erred when it invoked equity in the face of a complete contractual relief that was available to the refuge. All of the district court's errors germinated in its decision to apply equity. This court is reviewing the district court's decision de novo, and it's reviewing the district court's determination of South Carolina law de novo. South Carolina law is clear, and it holds that the basis for granting equitable relief is the impracticability of obtaining full and adequate compensation at law. In other words, in South Carolina, as it was in jolly old England and has been for time immemorial, equity is...
Ms. Tillman, wasn't the mortgager here bound by the mortgage to insure the mortgage property at issue?
Yes, Your Honor, that's exactly right.
So Abundant Life was bound by its mortgage to insure the property. If that's the case, under South Carolina law, the mortgagee has an equitable lien in the insurance proceeds per the Knapp case, doesn't it?
That is true under certain circumstances, and particularly, Your Honor, where the mortgagor, which in this case was Abundant Faith, breaches its covenant to protect the mortgage interest of the mortgagee. And in this case, the facts are clear that, in fact, Abundant Faith did not breach that covenant. There is a covenant to insure. Your
Well, it didn't insure the property for a time, right?
Yes, Your Honor.
Refuge had to go out and get its own insurance, which is why we have so many policies here.
That's correct. And initially, so we are looking at this case from the standpoint of what Abundant Faith promised to the refuge. And that promise is contained in the mortgage. And the mortgage does contain a promise to insure the property. And Abundant Faith initially fulfilled that promise by getting a first insurance policy with Stillwater. It subsequently allowed that policy to lapse, in which case the refuge noticed that and sent a letter.
So how is what you're saying? It sounds like what you're saying still falls within the South Carolina law in that Knapp case that would make there an equitable lien in this case.
No, Your Honor.
How is it different here?
It is different because equity is limited in its power and jurisdiction, and it only can be invoked when there is not an adequate remedy at law. And in this case, the law is the contract between the mortgagor and the mortgagee. And the contract says that the refuge will be covered by insurance. That's the requirement within that mortgage contract. And Abundant Faith initially allowed coverage to lapse, but then it fulfilled that covenant. It provided to the refuge an adequate remedy at law vis-a-vis the Guide 1 insurance policy, which Abundant Faith procured in fulfillment of its covenant. It's a direct insurance contract between the refuge as a mortgagee and Guide 1 insurance. And it is to that contract that the district court should have looked in trying to find a remedy for the mortgagee, which was the risk to the mortgagee was that church property that secured its mortgage might be uncovered by insurance. And so therefore the district court should have looked to see first at law whether there was coverage, and there was. That was the Guide 1 insurance policy. And also, interestingly, that mortgage contract also permitted the refuge to take out its own insurance in the event that coverage lapsed. And we know that the refuge did that. That's the Western World policy. And so contractually, the refuge had two remedies available to it. And yes, sure.
Now, the refuge shouldn't have had to have taken out the Western World policy, though, if Abundant Faith had done what it was required to do under the mortgage, correct?
Well, sure. And actually the mortgage contract covers that situation. It again provides a contractual remedy to the refuge in that event. The mortgage contract says that if the refuge has to take out policy, which it did, a policy, then it can recover the proceeds from the mortgagor, which is Abundant Faith. So again, there were contractual provisions that addressed all of the scenarios here. And
Ms. Tillman, can I ask a question? So you started off the argument by saying that there was more than abundant coverage here to cover the loss, and I think that's right. But isn't the question how that loss is to be allocated amongst the competing insurance policies?
That was the complaint, was a declaratory judgment to determine how that loss should be allocated among the competing insurance companies. And the answer is found within the contractual provisions of the insurance policies. And what we know from reading the contracts is that there was a direct insurance policy between Western World and the refuge. There was a direct insurance policy between Guide 1 and the refuge. And then there was arguably an insurance policy between Church Mutual and Abundant Faith, which did not name the refuge. And so from the district court, which had been asked to determine what coverage was available to the refuge, should have analyzed those policies to determine that there was coverage available both under Western World's policy and under Guide 1's, but none available under Church Mutual. That at law was the correct determination. But improperly, the district court, seeing three insurance companies before it, decided to sort of invoke equity, and it did it like a witchcraft gone wrong.
Well, Ms. Tillman, let me ask you about that, because I may well agree with the notion that it invoked a little bit too much equity here, because the question is, even assuming that someone is entitled to an equitable lien, that entitlement is only as good as the underlying right to insurance proceeds under the policy. So you don't step into any better shoes simply by virtue of the fact that you have an equitable lien. And it seems to me that that's where the district court might have gone awry, making an assumption that somehow the equitable lien put this particular party in a better position than it would otherwise have been. Isn't that the problem here?
That's one of any number of properties. If equity was properly invoked, then next, the district court erred in wielding its power improperly. And that the error there is that equity, even if it's properly invoked, cannot supplant the law. It cannot rewrite or supplant contractual provisions or statutory provisions that exist. And in this case, there was,
and that would include any defenses that might be available under the policy that the insurance company could assert against the original insured, right?
That's exactly right. In equity, properly, the mortgagee would stand in the shoes of the mortgager, and it would stand in the shoes of the mortgager vis-a-vis its direct contract with Church Mutual or whoever the insurance contract was, but it would not be entitled to independently entitled to any proceeds that the contract did not already provide to the insured.
Now, Ms. Tillman, can I ask you this? And I think this is the argument that you described is if the district court properly invoked an equitable lien, nevertheless, they had an equitable lien in nothing. And I think you made a couple of arguments, and I want to make sure I understand why it's an equitable lien in nothing. I think it'd be one of two things. One is that in the first instance, there wasn't a valid enforceable insurance contract because the consideration wasn't paid, all the reasons that you laid out and that the district court ultimately rejected. The other, and this gets to, I think, what Judge Diaz was asking, is if there was a valid defense. And in this case, on its face, it seems like there would have been a valid exclusion for arson, but your client, that wasn't raised at the summary judgment stage. As I understand, that was reserved for trial, so the district court never had an opportunity to apply that exclusion. So if it doesn't apply, what other defenses are available?
So it's not that it doesn't apply, and it was raised and it was reserved as a defense. It was raised as an affirmative defense. So the answer is properly. If the district court had properly found an equitable lien, then its next step would have been to interpret the Church Mutual policy and to determine whether, under the terms of the policy, it provided coverage to Abundant Faith. And that never happened, not because Church Mutual didn't raise it, Western World didn't raise it either. It didn't happen because the district court wrongly skipped that step. And it just found that that the refuge was independently entitled to proceeds regardless of the policy language, which it never analyzed. But yes, Church Mutual had raised as an affirmative defense the intentional acts exclusion within its policy, which at law would have excluded Abundant Life's claim to proceeds. And so therefore, really, it was in equity that the district court erred. It was in equity, in applying equity at all, and then applying it improperly. And for that reason, because equity should
because
never
you're
have
saying
been
the
invoked.
arson exclusion should have applied?
Sure, at law, if the contract had been interpreted at law, as opposed to misapprehended in equity and rewritten.
Well, wait, can we go back
equity.
to the equitable? What is your problem with the court at the second step? What step? You said the court missed the second step. What is it you wanted the district court to do? So that properly, the district court should have only interpreted the contracts as written at law. And so properly, what the district court, is that your question? The district court should have interpreted the Church Mutual policy as it was written. I guess my question was, assuming the district court was right to interpret it in equity, then what is your response to that? If it was proper to interpret the contract in equity, what's your next problem with that? And I'm sorry, Judge Diaz, caused her to go over time.
No, you take as much time as you need.
Well, thanks.
No, not you, Ms. Tillman. I meant Judge Thacker.
Well, may I have some time to answer Judge Thacker's question, please?
You may. That was a nice try, Ms. Tillman, but it's not true.
I'll try and do it as briefly as I can. And the answer is what the district court did, having found that equity applied wrongly. It then invoked just an entirely other equitable doctrine, which was reformation of the contract. It rewrote the contract without performing the analysis that would have been necessary to equitably reform a contract. And in fact, later in a subsequent order, it found that there were no grounds for equitable reformation because there was not a contract in there between the refuge and Church Mutual. And I thank you very much.
Thank you, Ms. Tillman. Mr. Waring?
Thank you. Brad Waring on behalf of Western World, the appellee, and my partner, Kenny Gardner, will reserve 5 minutes for him to answer some questions or at least talk about two other matters that came up. What I think the court gets it. What this case boils down to is an objection.
I don't feel like I get it yet.
Well, I think what it boils down to is an objection over Judge Seymour's application of the time-honored principles to provide a fair and equitable remedy in a case with extremely unusual, some would say bizarre, I suspect, facts. This is not your average run-of-the-mill failure to name a mortgagee on a policy of insurance, and thereafter, as Judge Diaz properly pointed out, what you usually have in that circumstance is that the mortgagee who was not named would rise and fall on the fortunes of the underlying insured. The facts here is what makes the case so bizarre. And yes, this is a de novo review, but the appellant has the burden of convincing this court that the preponderance of the evidence was against Judge Seymour's findings. And we'll come to those facts in just a second. At the outset, it is important to note that she cites Regions Bank versus Wingard as the kind of bellwether for utilizing a equitable remedy. We contend that case holds the key to upholding her decision. There's probably no reported case in South Carolina that better summarizes the jurisprudence of equity and its application. One of the cases in Wingard that's cited is Brown versus Plata that says, once invoked, the scope of a district court's equitable powers is broad, for breadth and flexibility are inherent in equitable remedies. So, the notion that a policy was not issued is a little ludicrous. All one has to do is look at the appendix number 280. It's a letter of August the 5th, 2016 from Church Mutual's claims manager to Abundant Faith and Pastor Bank.
Is that when he said he pushed the button?
No,
he already pushed the button?
He'd already pushed the button by then. This is even better. We understand that you have hired Mr. Bob Freitag to assist you in the adjustment of your claim. The letter goes on to say Church Mutual issued policy number, and then it gives the policy number, to Abundant Faith Lighthouse of Jesus Christ Church. Effective policy dates are 7/6/16 to 7/6/17. Interestingly, that letter was copied to the agent, Bob Jurek. Church Mutual then began to investigate the loss and took an examination under oath of Reverend Banks. And one has to ask merely, how in the world could Church Mutual avail themselves of the contractual right to take an EUO if no policy ever existed? I mean, the inquiry can stop there. There's a lot.
Could I ask you this question? I mean,
certainly.
Assume that I agree the facts of this case are paradigmatic of when an equitable lien applies, that there was a policy issued, it was binding, and that Abundant Faith was contractually obligated to list the mortgagee, and it didn't do that. So you check both those boxes. The argument I'm having trouble with is because you had this Guide 1 policy that covered more than the mortgage amount, why isn't that an adequate remedy at law? And why doesn't that trump, whether the district court got it right or not, the application of equitable lien?
I believe that Judge Seymour believed that without allocating, that would be unfair to Guide 1. You've got to remember that this was a declaratory judgment brought by Guide 1 for allocation of the proceeds. Guide 1 was adamant that not only had Church Mutual issued a policy, which I think I've just established, but in addition, that the failure to name the mortgagee was either negligence, a mistake, or on behalf of Church Mutual. And those are the facts that I referred to earlier, and I'd be happy to turn to those.
So in other words, suing Guide 1 doesn't remedy that wrong. In other words, the failure to list the mortgagee. That
is correct. And I believe what the appellant can't seem to stomach is that once the court came to the conclusion that Western World possessed an equitable lien, which is the law in South Carolina, an unnamed mortgagee possesses an equitable lien in the proceeds. And Judge Diaz has it exactly right. The real issue is, well, does that mean that they're subject to the defenses that they may have against the insured? In this case, because of the very strange facts and circumstances, the court properly invoked equity to find an equitable and fair remedy. Part of that was the finding that there should be an allocation based on the pro rata amounts on the two policies that existed. Now, to jump the hurdle that Judge Diaz has an issue with, you've got to look at these facts. And I'm just going to list a few of them because they are fairly compelling. First, the reason that Banks was shopping for coverage in the first place was because he'd received a letter from the mortgagee, the refuge, about him letting the Stillwater policy lapse. He recognized his duty to the mortgagee to protect him. He had just done so on the Guide 1 policy just a few days before. The uncontradicted evidence in the record is that Church Mutual's agent, Zurich, who is, by the way, a direct employee of Church Mutual, met Banks at a local McDonald's because Zurich needed Wi-Fi to complete the application for the Church Mutual policy. Interestingly, his affidavit at Appendix 513 is completely silent as to whether he asked Banks if he had a mortgage. The only evidence in the record is that he never asked Banks whether he had a mortgage. One has to wonder how an employee who is writing almost $800,000 in building coverage without inquiring if the property is subject to a mortgage, how an agent—
Mr. Waring, can I ask? I'm sorry to interrupt you, but maybe you're going to get to this, but how do these facts support your argument, which I think is coming, that somehow trumps the conventional law that someone who is entitled to relief and equity under an insurance policy rises or falls on the text of the policy, including any defenses?
I think that Judge Seymour recognized that and I think all you have to do is take a look at the Supreme Court case Camp versus Boyd that says equity relieves of consequences of accident and mistake as well as fraud. There's a South Carolina case cited in Wingard that says for one to have notice of an outstanding equitable interest, it's not necessary to know the identity of the third party or the extent of his interest. It is sufficient that one either knows, and this is the key phrase, or ought to know some third party interest exists. And that's precisely what the facts showed here. Zurich didn't ask.
Okay, but again, all that seems to suggest is that entitles your client to an equitable lien, but it doesn't address the question of whether or not that somehow trumps all of the conventional language that suggests that lien is only as good as the text and substance of the policy. What's your best case for that notion that equity can rise so far as to dispense with defenses under a policy for someone who has an equitable lien?
Under these facts, Your Honor, all I can say is that there is no defense of arson under this particular matter because—
Well, that's a different issue. You might well prevail on the merits of whether or not they're was a defense, but the question is whether or not the insurer in this case is entitled to assert that defense.
Well, it wasn't raised below, as was pointed out. First.
Well, your opposing counsel said it was reserved below.
I'm not sure what she means by reserved, but I don't recall it being argued at the time of the motion hearings. I could be wrong about that. I wasn't prepared to go back and look at that. We addressed it by virtue of the fact that whatever charges, if they're trying to deny on an arson defense, to claim that there was arson and fraud that took place in the case, and they were relying on a criminal investigation, that has been non-pros. So that's where we are. I'm getting over my time for Mr. Gardner to speak, and so unless there's other questions I can respond to, I'd like to turn it over to him.
Well, I think we're going to go in order of, let's see. Right, Mr. Gardner is going to speak, but so is that all you have, Mr. Waring?
No, that's not all I have.
That's an open. Sorry, I asked that question that way. So if you want to cede your time to Mr. Gardner, that's fine.
I will, Your Honor. I would just say in conclusion that if you adopt the argument that the appellants are pressing here, you would be holding, and it would be unjust, we believe, that Western World forfeit its debt, or the debt that's owed under this scenario, and that equity abhors a forfeiture. So, Mr. Gardner, I'll turn it over to you.
May it please the court. My name is Kenny Gardner on behalf of Western World, and I'm here to specifically respond to the appellant's two arguments in its brief. The first, that the district court's ruling that Western World's policy was excess to that of Church Mutual and Guide One, and that the district court's ruling that Western World's assignment of the mortgagee interest did not extinguish its right to the judgment regarding Church Mutual's unpaid pro rata share. We've discussed some of the first argument already on whether or not that there was an insurance policy. I think the facts are sufficient to show that they were. All of the material terms were agreed upon. Mr. Banks may have intended to cancel the policy later, but he certainly intended to enter it. And when he attempted to cancel it, they told him it was too late. They then issued him a policy, and at all subsequent times of the fire loss, acted as if there was, in fact, a policy intact until 4 months after the fire loss. With regard to the position that there was no consideration, again, despite no payment of the premium, they still issued a policy. And they took no.
I'm sorry to interrupt you, but I have a question. You mentioned just a second ago, kind of the last issue of the analysis, and all of this is difficult, but this is one I'm really struggling with, is this excess insurance issue. The district court held that the Western World policy was in excess of the Church Mutual policy, and you know South Carolina property law better than I do, but as I understand it, essentially a valid excess insurance clause provides coverage for amounts that exceed limits of other insurance covering the same risk in the same property. Do you agree with me on that?
That's part of it. It also requires the same insured for the same period. Okay. And that's Blanding versus Long Beach Mortgage. And in this particular case, they were not the same insured. Church Mutual insured Abundant Faith's mortgage interest. Guide One insured Abundant Faith's mortgage interest. Western World insured the mortgagee's interest of the refuge. So they were.
So that's my question, right? The mortgagor's interest and the mortgagee's interest are separate interests in property. So if you apply this rule about valid excess insurance, Western World cannot be in excess to Church Mutual because they insure different property interests. A mortgagor's interest versus the mortgagee's interest. So I just don't follow how you get to Western World as excess to Church Mutual, if you can help me with that.
Well, it's other insurance, and what it is that you have to look at what the risk the policies attempt to insure. So because both Church Mutual and Guide One insure abundant faith's interest, those excess are canceled out and they are responsible for a pro rata share. Our policy says very clearly that if there's any other insurance, whatever the circumstance, we will be in excess of that. And the court properly, we believe, found that. Going through, turning to the next point of Western World's assignment of the mortgage interest didn't extinguish the pro rata share. Western World remained the real party in interest to the sums due and owed by Church Mutual. Western World paid the refuge for its mortgage interest and took an assignment of all of its rights, including the mortgage, to pursue Church Mutual for its pro rata share. That's exactly what we did. We took it to pursue Church Mutual. We received a judgment against Church Mutual for its pro rata share. And the court found that we were entitled to the sum. An equitable lien is neither an estate or property, and the thing itself is simply a right of special nature over the thing, which constitutes a charge upon the thing. And moreover, an equitable lien is a mere floating equity until a judgment or decree subjecting the property to the payment of the debt or claim is rendered. But even though not judicially recognized until the judgment declaring its existence, it relates back to the time it was created by the conduct of the parties. And here, that's exactly what the court found, that Western World had a special right, an equitable lien, in the sums owed. It wasn't solely on this mortgage. We paid the money that we were otherwise not responsible for paying. When you read all of the other insurance clauses together, and it relates back to where Western World paid the refuge. That's where that interest comes in. It goes back farther when Church Mutual refused to pay the refuge. The lien itself is on the sums owed pursuant to Church Mutual's policy. And the pro rata shared by Church Mutual established the judgment. And lastly, we never assigned those rights. We never assigned the rights to go after that sum against Church Mutual. The release very clearly says that we carve that part out so that we can continue to collect the pro rata share, because otherwise we're not made whole. We paid 2 shares that we were not responsible for paying. And because we expressly reserve those rights, we are entitled to the judgment that was already issued and rendered against Church Mutual. The manifest injustice that Church Mutual refers to by not forcing it to pay a pro rata share, that wouldn't be the manifest adjustment, but allowing a complete forfeiture of Western World's rights as assignee in those sums owed. I mean, again, the court, in trying to and employing its tools for equity, found that because they insured the same interest, they canceled each other out. Therefore, we were excess. So unless those Church Mutual and Guide One policies didn't cover it, Western World never came into play, or was not supposed to.
Mr. Gardner, can I ask the question, and I'm sorry to take you back to the beginning of your argument, but how does the district court's ruling with respect to which policy was excess affect your right to recover under an equitable lien theory? I mean, why does it matter?
Well, that's how the court got to the amount. So they're saying that we are entitled to whatever the mortgagee was entitled to, in this case, the refuge. And so it was an equitable lien on that sum of money, or its pro rata share, the $99,000.
So is that something less than you say you're entitled to? Or I'm just trying to figure out how
the $99,000 was their pro rata share of the loss, according to the amount of coverage in both it and the Guide One policy. So that's how we get to that. We believe that the court properly employed its tools for equity and fashioning a remedy to avoid a forfeiture on behalf of Western World. and essentially allowing Church Mutual to outlast or wait this case out, putting your hand on the proverbial car and being the last one to take it off wins the car. That's essentially what we have here. Is Church Mutual is claiming, well, no, you assigned I see my time's up. May I finish briefly? And
you may go ahead.
Church Mutual is taking the position that, well, you assigned the right, so now it's too late, even though you've got a judgment, and that's just not equitable at all. Thank you, Your Honors.
Thank you, Mr. Gardner. Mr. Ford?
Thank you. I think I am the anchor leg in this race, and I feel a burden to make it all clear and simple, which is a heavy burden to bear in this case.
Failing that, Mr. Ford, you could grab that guitar behind you and strum a few bars.
We are a full-service firm, Judge, so if that's what you require, it shall be done. I agree with my friend, Mr. Waring, that this is a bizarre case. And given that, I think it's helpful that there is a nice case on point. It is from our sister state of Maryland, but it is the Clemens v. American Casualty, and it's a district court, so it's not binding, and y'all are the boss, so y'all decide. But I would suggest going through the facts of the Clemens v. American Casualty case, and it kind of traces this kind of situation where there's a mess, there's complexity, there's a mortgagee and a mortgagor. I think there may have been an unsavory brother-in-law involved in that case. So,
Mr. Ford, I have a couple of questions, sort of following up on your co-counsel's argument. So was the arson exclusion or the arson defense raised below somewhere? Did that factor into the district court's summary judgment?
It was preserved at page 413 of the appendix. And basically what happened there was the Church Mutual did have a defense against its insured, arguable insured abundant faith, that because of deliberate acts. So I think we can probably agree if you burn down your church, you don't get insurance proceeds for it. What happened, however, with the district court was the district court decided there was an equitable lien, and then going to Judge Diaz's point, decided that they had a right to the proceeds. But as Judge
wouldn't that have been the point where you all would have argued about the arson exclusion in the policy?
If we had gotten to that.
Okay, go ahead.
Sure. If we had gotten to that, but this is the mistake that the district court did that skipped that step. It said there's an equitable lien.
But why didn't you? Right. Okay, go ahead.
I'm trying to get there, but if I'm not, tell me and I'll redirect. It says there's an equitable lien, therefore you're entitled to be paid. This is the step that was improperly skipped. What should have happened then is the refuge steps into the shoes of abundant faith, but is subject to all the problems that abundant faith is subject to. And at that point, there should have been this discussion and a hearing on whether there was arson, whether the deliberate acts exclusion applied, and so on. But the district
So, Mr.
court
Ford, how does that work procedurally, right? So if the posture is summary judgment, is the court to grant summary judgment on the equitable lien issue, and then the parties are free to litigate the issues of stepping into the shoes, and at that point the affirmative defenses come to the fore and those issues are litigated? I'm just trying to conceptualize how that would work, given you didn't really raise it at summary judgment.
Okay. So I'm
and I don't see it at JA 413. But go ahead.
Okay. Okay. I'll take one. So the way it would have worked below is, first, I'll put aside the fact that equitable lien did not need to be invoked because there was no other policy. I'll just take, assuming the equitable lien was invoked, as Your Honor's question is. At that point, the refuge steps into abundant faith as the insured and makes a claim under the policy. And I'll remind the court, and I'm going to proceed with the question, that the insured abundant faith never made a claim under this policy. That never happened. The only claim that was made was by the mortgagee, which is a separate interest. So, but I'm going to take the question as it was posed. The refuge steps into the mortgagor's shoes. Then what it needs to do is, first of all, make a claim. which was never done. And then the Church Mutual has the opportunity to say, okay, now, for the first time, we have a claim from our insured. But we have this deliberate acts. We have the dentist and the burning down and so on. So that is, at that point, there's a hearing as to whether it was improperly denied. But we didn't even get to that step because the insured, Church Mutual's insured, never made a claim. And we know why, because they didn't think they had a policy, and they had a policy, Guide 1, that solved everything. Church Mutual doesn't need to be a part of any of this because there's a simple solution at law that is a $1.5 million policy from Guide 1 that names the refuge. And it also names abundant faith. It solves all ills under law, and therefore equity does not need to be invoked, which gets me back to my original point. That equity should have been invoked, and there is no need for an equitable lien at all. In South Carolina, equity is only invoked when there is not an adequate remedy at law, and there is a completely adequate remedy at law. I heard my friends on the other side of the aisle talking about fairness.
But if we found that equity in the first instance was properly invoked, then do you just lose, or what would you want us to do?
If your honors decide that, okay, there should have been an equitable lien, there was an equitable lien, that is on, and this is clear under South Carolina, on proceeds. The question then goes back to the trial court, are there proceeds to be paid under this policy? And that invokes the problem of there has to be a claim made by the insured, was there a deliberate act, and so on.
Mr. Ford, can I ask a question? As I understand South Carolina law, if the mortgagee had actually been named as an insurable interest under the policy, then irrespective of whatever defenses the original insured might have had, the mortgagee is not necessarily limited in its ability to recover because of the fact that these are different insurable interests. So specifically here, if the original insured burned down the church, we don't know that for sure, but that seems to be the allegation. But in this case, the mortgagee had actually been named in the policy. That defense would not be available to the insurance company against the mortgagee. Is that right?
That's my understanding, subject to the language of the policy. But if they had been named in the policy as they were in the Guide 1 policy, then my understanding is what you characterize it correctly, Your Honor.
All right.
And Mr. Ford, I did find your reservation at footnote 4 of JA 413, so I did find it. You are correct.
All right, Mr. Ford, thank you. We understand your arguments. We appreciate the arguments of all the counsel here this afternoon. The case has been submitted. We would typically come down from the bench, as some of you may know, and personally greet you. We obviously cannot do that this afternoon, but know that we are thankful and grateful for your appearance before us and hope to someday be able to meet you and greet you in person. So thank you very much. We'll move on to our next case.
Thank you, Your Honors.
Thank you.
New River Electrical Corporation versus Occupational Safety and Health Review Commission. And counsel for the petitioner, Mr. Priotel, did I pronounce that right?
That's correct. Yes, you pronounced it correctly.
All right, sir. Go ahead.
A lot of people get it wrong, but you got it right.
You may proceed.
Yes. May it please the court, Keith Priotel for the petitioner, New River Electrical Corporation. And we are here on review of a decision and order by the Occupational Safety and Health Review Commission. And I know the courts have read the briefs and gone through the facts underlying the citations that were issued. So I'd like to start with each citation item and go through each item and the arguments and the analysis used by the administrative law judge deciding the case. And it begins with citation 1, item 1, where the judge took what was a singular citation under 1926-961b4 and carved it up into two separate ostensible violations by taking the each crew shall independently comply with this section precursor of the citation or of the regulation and applying it to the facts in this case. And what the judge did, the administrative law judge did, was said, well, there's a cite under citation number 2 that relates to 1926-961. So if we find a violation of that independent citation item number 2, that necessarily means there's a citation of citation 1 item number 1 under the independently comply clause. And then the judge also cited a regulation that had to do with protective grounding in the electrical environment. And it was a regulation that was not cited against New River Electrical Corporation in any form or fashion, 1926-962C7, and said, well, even if citation 2 can't be the supporting basis for citation 1, then this independent regulation for grounding can serve as the predicate for that each crew shall independently comply with this section clause. Couple problems with that we have briefed the court that we have with the analysis, at least with respect to that clause employed by the administrative law. First is neither party, no party, neither the secretary, frankly, neither New River argued that each crew shall independently comply with the section clause could bolster or predicate a OSHA citation. I've taken the unusual move of putting in the record.
Okay, but before we get to all the details of the citations, do you have an argument under Wilson and Sons about the burden of proof here and whether it was incorrectly placed on your client as opposed to the government with regard to the unpreventable employee misconduct offense?
Yeah, I think we do, Judge. I think in your circuit where knowledge cannot be imputed through the mere supervisors or foremen that are on the site, and you have to show in the Fourth Circuit foreseeability, then the burden is on the government to, I guess, disavow the factors of employee misconduct rather than us having to prove the factors of employee misconduct.
Well, so, did the ALJ or the commissioner here improperly place the burden on your client?
It was placed on us. The burden was placed on us, Judge. Traditionally, in employee misconduct, it is an affirmative defense in OSHA proceedings. And the judge did place the burden on us when it should have been placed on the government. Irrespective of that, there's factors in the employee misconduct that I'll get to later that I think may make that burden of proof issue and the shifting of the burden of proof to New River. It may bring it into more foresight for the court.
Yeah, because of course, if the burden of proof was improperly placed on you, then shouldn't we send it back?
That's grounds for reversal, Judge, but there may be grounds for really just entering an order in favor of New River rather than sending it back. So I'm going to return back. I don't want to get off track, but I'm going to return back to what the judge did with divvying up that regulation.
Mr. Freitag, can I ask you about that? Because you may well have a point about this improper division of the liability under that subsection. But if we, I guess it really wouldn't matter, would it, if the ALJ's finding that there was no system operator in charge of the lines, that separate finding would be sufficient to uphold the violation, right? So I think maybe you need to focus on that.
Yes, Judge. You're right. There's a separate independent requirement, and the predicate for having separate tags and coordinating de-energizing and energizing under the regulation requires that no system operator be in charge of the lines or equipment. And during the course of the hearing, every witness, including the government's expert witness, including the compliance safety and health officer, including the two former foremen of New River, testified that AEP was the system operator. And then we get to what the administrative law judge did is it delved into the preamble to the regulation and said, well, if you're going to the preamble of regulation, then the system operator in charge of the lines of equipment has to be in charge of all the lines and equipment. But there's a finding of fact at the very beginning of the administrative law judge's opinion, where he said that AEP de-energized the lines and equipment through DDC, the controlled dispatch arm of AEP. That's true. The whole outage was begun and the de-energizing had to go through AEP's DDC unit. And that's a finding of fact.
Right. Well, even if that's true, but weren't the crews re-energizing the lines throughout the day? So, I mean, weren't they actually in charge?
So the judge said they were re-energizing and de-energizing, and that's wrong. They did re-energize at one point during the day. Yes, they did. When they had the south riser loop and the south riser poles completed, they energized the south riser. But what do you do with that, Judge, where you have one aspect where AEP is the de-energizer of the lines and equipment, and the crew is the re-energizer of the lines and equipment? And that really goes to what we've argued in our brief is this regulation, and this is the first time someone's tackling this regulation. No one's been on it before. No one's really looked at it before, and there's no case law on it before. Did it give fair notice to New River? And when you're using a decision to announce how a safety standard is supposed to operate, that bears on the adequacy of the notice provided.
Mr. Prytel, could I ask you, if we're talking about the specific standard in B4.2, right, which turns on this definition or existence of a system operator, and you take issue with the fact that the ALJ looked to the preamble in order to understand and apply that definition in this case. But before he got there, he looked at the definition itself, right? And that definition is not very helpful. A qualified person designated to operate the system or its parts, it's kind of circular. The context of B4.2 doesn't provide any additional help. And then you get to this preamble, which, as the ALJ articulated, is precisely the scenario that existed that day in the subdivision, where you have multiple crews, you have the underground and the riser crews doing different things, and you don't want them making assumptions about what the other crews have de-energized or not. So why was it improper for him to look and apply that preamble, given the ambiguity of the definition of it itself?
Well, two reasons, Judge, because even under the preamble, it says the system operator is the person who's de-energizing or re-energizing all of the equipment. That was the term used, all of the equipment. And that's not the factual case here. The de-energization in the morning occurred through AEP. It did not occur through anything these crews did or could have done. So it's a little different than when the judge just block quoted that same section of the preamble and said, this is exactly what they were doing, de-energizing and re-energizing. First of all, they weren't de-energizing, and the only thing they did is re-energize when they got done with the risers related to the south loop. I would agree with you, though, Judge, that the standard on its face is not very helpful in its circular definition of what a system operator is. I mean, it is circular. And everybody, like I said, testified. Everybody, even the government's witness said, yep, AEP is the system operator here. Their experts said they're a system operator. I'd like to get on to the knowledge element, Judge Thacker, which I think kind of goes into the misconduct that you raised and the burden of proof as well. The first thing, obviously, the administrative law judge did was that it can be imputed through the mere presence of the foreman and the actors. And this court's Ocean Electric decision, of course, had rejected it. In fact, the judge noted that the Fourth Circuit takes a different view of how you establish knowledge under the Fourth Circuit's body of case law. But then he went on and found foreseeability and really did it through what he called time constraints, that the crews were under time constraints. And because they were under time constraints here and were rushed to do this job that we should have known, there are like 8 facts that are nowhere mentioned in the administrative law judge's opinion that run directly counter to any suggestion that these crews were under any kind of rush to complete the project that day or any other day. And when you look at something under the arbitrary and capricious review standpoint, you have to at least acknowledge evidence that runs counter to your finding of fact. And I think the judge had a problem with this because of the two witnesses the government used in its case were both, we know who they were. I mean, they were serial liars. They were the people who fabricated the scene after it was all over with. So he couldn't have a credibility dispute between those two. But the facts were that Zach Howard, one of the foremen, was told 2 weeks prior to this particular incident that he could use all the overtime he needed to complete the project. Don't worry about any kind of overtime. If you think you need overtime, use all the overtime you want. On the morning of the day of the event, Mr. Howard told Superintendent Barnhart that if he could have additional help, and Barnhart told him, look, call me if it looks like you're not going to make your outage. And that's in the trial transcript 206. And that fact's nowhere in the judge's opinion, nowhere mentioned in the judge's opinion. Later on in the day, Superintendent Barnhart initiated that conversation. So instead of placing the burden on Zach Howard to call him, he called him and asked if he needed extra help. And he said he didn't meet anyone. That's an undisputed fact. That's the trial transcript or the joint appended transcript 391. And then throughout the day, Foreman Howard contacted Superintendent Barnhart to call in these bad transformers that they were finding. And never once did he ask for extra help, as was the directive at the beginning of the day.
Mr. Pryatel, can I ask, before you run out of time here, that was part of the ALJ's basis for finding or imputing knowledge, but I thought the other significant part of the ALJ's opinion was a concern or the finding that the company's safety plan was inadequate, and then he listed a number of reasons why that may have been the case, including the fact that you had 3 managers on the job who failed in some degree or another to do what was supposed to have been done, suggesting that showed some unanimity of non-complying conduct that suggests in turn the lax enforcement of safety rules. And he went on. So I'd like you to talk about that aspect of the ALJ's ruling.
Yes, Judge. I would take they said the fact that foremen are involved in this is a strong suggestion of a lax safety program. They couldn't carry it much further because of the law on the circuit that almost would be imputing knowledge. It'd be the same thing. But the 2 other factors that the judge mentioned, and that it's very hard to defend and it's almost impossible to defend when it says, hey, you guys don't have enough electrical hazards here that I could count. I mean, that may be true, but that should be a good thing. That should be in our favor that we don't. These are an International Brotherhood of Electrical Workers, apprentice-trained journeyman workers in the field. They should not have a lot of electrical-related instances of misconduct or happenstance. But the judge kind of used that against us and said, well, I'm looking through your disciplines here, and it doesn't look like you have a whole lot of write-ups about that. But really, it should be in our favor, not against us. And then the judge said that one time a month surprise audits of 5 hours was not of a sufficient frequency, and that most of the safety disciplines occurred after an incident of property damage. Well, I think in our reply brief, I'm over my time, I understand it, but in our reply brief, Judge Diaz, we did note that his counting was certainly off. When you go through the 200 and something disciplines that were entered into the record, there were a number that had nothing to do with property damage or an incident occurring, and they were preemptive in nature with respect.
All right, Mr. Pryatel, you've got some time reserved for rebuttal, so I'll let you respond on the back end. Ms. Chong, we'll hear from you.
May it please the court, Jen Chong representing the Secretary of Labor. This court should affirm the Commission's final order because there is substantial evidence supporting the ALJ's decision, finding that New River failed to 1, coordinate de-energizing and energizing, 2, de-energize and tag, 3, de-energize and place grounds, and 4, demonstrate unpreventable employee misconduct. And as New River found in its own incident report, production outbalanced safety due to time constraints. And there was a lack of leadership, planning, and communication. As a result, New River's employee...
Ms. Chong, under L.R. Wilson and Sons, whose burden is it on the unpreventable employee misconduct defense? Isn't it the government's burden to prove that or must be disproved by the Secretary of Labor in his or her case in chief, according to the Wilson case?
According to the Wilson case and the Fourth Circuit decisions on employer knowledge, it is the secretary's burden to prove that a foreman or a supervisor's misconduct was foreseeable.
It seemed to me throughout the opinion that the burden of proof was misplaced onto appellant here rather than the government. Can you disabuse me of that notion?
Yes. So on page 20 of the ALJ's decision, the second full paragraph, the ALJ wrote, quote, in addition.
What's the JA page?
Oh, sorry. Okay. JA 104.
Thank you.
104.
And where is it you want me to look?
The second paragraph.
Okay.
He wrote, in addition, even if the court applied Fourth Circuit precedent to this issue, the court finds that the violations by respondents' foremen were foreseeable. And so the ALJ properly applied this circuit's case law regarding employer knowledge.
I mean, the ALJ properly acknowledged, I guess, the case law, but there are times it seems that the burden was put on the appellant rather than the government.
As the ALJ
but,
found,
you know, appellant's counsel doesn't really seem to agree with me on that either, so that'll be his argument to make, I guess.
Your Honor, on that point, as the ALJ found, the foreman's misconduct was foreseeable based on New River's very inadequate safety program, and as well as the time constraints that the foremen were under that day due to the change in the scope of work. Significantly, you know, as the ALJ wrote, the adequacy of a safety program is dependent on a variety of factors, including the amount of job training received by supervisors, employee competence and experience, safety records, practicality of supervision, and degree of dangerous and hazardous work. And here, the work that was being done was highly dangerous. And also one of the foremen, one of the three supervisors on site, was just vaguely familiar with the grounding policy that they had. And he did not know of New River's tagging policy despite being a supervisor. Even though New River's own policy required an approved grounding plan, the foreman failed to create that before the start of their work that day. And there were no new JSAs or JHAs despite the change in the scope of the work. Also, New River's own incident report on page JAE 444 states, quote, the unforeseen damaged defective transformers that were replaced during the outage caused the scheduled outage deadline to be exceeded. This created a production lead safety behavior, thus resulting in a series of poor decisions. And so, Your Honors, New River itself found that there were timing issues and that because of those issues, these crews were making poor decisions.
Ms. Chong, but even if we accept all of that, how does that establish sort of the company's knowledge if we assume that this is a one-off incident? And one of the arguments Mr. Prytel makes is that the department, in this case, the commission, took the company's data of its enforcement of safety rules over the years. It was a limited data set, saw that there was a paucity of punishments for preemptive violations, and somehow equated that to the fact that the company was lax in enforcing its rules. But I suppose, I mean, an equally reasonable observation or analysis of that data is that the company was doing a good job, and therefore there wasn't a need for a great number of disciplinary proceedings. It seems, I mean, why isn't that right?
Well, if you just look at the incident itself, there were 3 different supervisors that failed to create a grounding plan as was required by New River's own safety rules, and also failed to place tags or to ground the transformer. And so there are 3 supervisors that are violating New River's rules. And so I think it's a very difficult argument to make that just because there's a lack of written disciplinary records of these type of violations, that these violations were not happening. And as the ALJ found, these safety audits were inadequate. He wrote that given the gravity of potential harm, the violations by multiple supervisors here, the change in the scope of work, and that most of the safety violations found by respondent were identified after property damage, the court considers a safety inspection of only once per month inadequate.
Can I follow up on that? You made the argument that, you made the argument that, you know, you had 3 supervisors involved and they clearly knew better. But the fact is that they, in fact, did know how to do this because they covered it up by engaging in the very kind of safety precautions that they should have taken on the front end, which suggests to me that the company did train these folks properly. They just decided to go off on their own. Why should we hold the company accountable for that?
Your Honor, as the ALJ found, yes, the company did have safety rules. And yes, they did communicate these safety rules through training. However, they failed to take adequate steps to discover violations and to effectively enforce their safety rules. And because of those failures, the court can conclude that this safety program at New River was inadequate, just because there are safety rules.
Mr. Strong, let me ask you this. I think one of the things you would point to, and I don't want to put words in your mouth, is, for instance, that Mr. Barnhart, I think he was the safety manager, testified that, you know, we disciplined folks for failing to ground, but in the 238 pages of records that were provided, there's no corroboration for that, is there?
Yes, I mean, even though Superintendent Barnhart had said that, you know, there were disciplinary actions, he couldn't recall a single incident where an employee had failed to ground or tag, despite working for New River for 15 years. And he did not, even though he was a foreman and a superintendent, actually discipline an employee for failing to follow these rules.
John, can I get you back to the first part of Mr. Priatel's argument regarding the first violation that he argues is simply an improper? It's improper because the commission in this case divided the violations into 2 separate ones without adequate notice of the precise violation, simply by relying on this catch-all provision in that section of the regulations. So what's your response to that? It does seem a bit odd the way that was handled.
Your Honor, as I think you mentioned yourself, even under that rationale of the judges, if New River violated the second half of that provision, this court can affirm that or uphold the judge's finding that New River failed to coordinate the energizing and energizing. In addition,
are you conceding? Honor, are you conceding then that his argument is well taken with respect to the first part of that violation? No,
Your Honor, because the ALJ found that if you look to page 14 of his decision, JA098, it's just a very short quote, but the ALJ found that, quote, the violation cited in item 1 is clear, and this was based on the crew's failure to ground or verify that grounds were in place. And so the ALJ made or found this finding based on the failure to comply with item 1. So he didn't have to go to the other cited provisions to reach his conclusion.
I'm sorry, I can't help myself. I'm going to go back to the burden of proof thing. I know you directed me to JA 104 as to you know, where the ALJ said, oh, if they applied Fourth Circuit law. But that didn't have to do with the defense of employee misconduct. That comes up much later in the ALJ's opinion. And I think you agreed with me that the employee misconduct must be disproved by the Secretary of Labor in his or her case in chief, right? It's the burden of proof of the Secretary of Labor to disprove, I guess, the employee misconduct, according to Wilson and Sons. Okay, and then what I was talking about, if you look at starting at JA 117, which is where the ALJ actually addresses the defense of employee misconduct, throughout that section is where there are discussions about the appellant here, petitioner, having to meet the burden, as opposed to the government. So,
yes, Your Honor, it is the Secretary's position that while we have to show that the foreman's misconduct was foreseeable in order to impute a foreman's misconduct to the employer, in order to prove employer knowledge, it is New River's burden to prove affirmative defense of employee misconduct.
okay, it's New Rivers. Okay, well, I thought earlier you agreed with me when I read the Wilson and Sons opinion, or part of it. It says, unpreventable employee misconduct must be disproved by the Secretary of Labor in his or her case in chief. So,
sorry, Your Honor, could you repeat just that part?
Okay. In Wilson and Sons, a Fourth Circuit case, it says unpreventable employee misconduct must be disproved by the Secretary of Labor in his or her case in chief. So that sounds like the burden of proof, although oddly, because it says disprove, was on the government. But in the ALJ's opinion, starting at JA 117, there are numerous references to the burden being on the respondent. I mean, I don't want to take up a lot of your time if you're not. That's a convoluted question, I guess, if you're not prepared for that.
Your Honor, I can provide a supplemental brief on that issue if you'd like me to.
Go ahead with your argument, and I'll try to make myself more clear in a minute. Your argument, go back to what you were arguing. You can forget about that question from me for now. I'll try to make myself more clear in a minute.
Okay.
Well, I guess just to kind of follow up, and I don't want to beat a dead horse here, but the provision, the paragraph that you cited earlier, Ms. John, clearly acknowledges the Fourth Circuit law on the fact that you can't impute knowledge to an employer simply by virtue of the misconduct. You've got to show something more. And it appears that this affirmative defense perhaps bleeds over into some of that, but ultimately, as best I can tell, and of course Mr. Prytel can respond, but it appears at least at first blush that the ALJ did properly allocate the burden, at least on the front end, but
yes.
You can, I mean, do you agree with that?
I agree that the ALJ properly applied Fourth Circuit precedent to the employer knowledge element of the Secretary's prima facie case, as in that, a foreman's misconduct must be foreseeable for that misconduct to be imputed to the employer, right? That's established Fourth Circuit law. And the ALJ properly did that, as I pointed to in that paragraph.
Right, and that's at JA 104 that you pointed to before, correct?
Yes, I believe so. And as Judge Diaz said, maybe those two concepts bleed over to each other. And so I have acknowledged, yes, that the Secretary has that burden to prove foreseeability. in order for a foreman's knowledge to be imputed.
Okay.
But
Ms. Chong, do you have anything further? Do you have anything else? I don't mean to cut you off, but.
Your Honors, if there are no additional questions, the Secretary just asks this court to uphold the ALJ's findings based on substantial evidence.
Thank you, Ms. Chong.
Thank you.
Mr. Prytel, you've got some time for rebuttal. Go ahead. You're on mute, sir. We can't hear you.
I'm sorry, Judge. Just briefly, Judge Thacker, just so there's no confusion, I am in agreement with the burden of proof on employee misconduct, and you preempted me by finding it at JA 117 to 118, where clearly the judge said that the burden is on the respondent with respect to that defense. With respect to the argument of this production over safety, and that's in New River's report where it did a analysis, root cause of what happened here. The production over safety wasn't anything imposed on the employees by the company, though. If these employees wanted to get off that work site and get home, in a timely fashion rather than spend the 16 hours that they had as IBEW journeymen to work that site, that's not on New River. That's nothing we compelled them to do. So that statement in the production over safety really was these employees wanted to get off the site, not that the company imposed on them to stay on the site. Judge Cullen, you brought out the fact that, there was this discussion from Mr. Barnhart and the questioning by the ALJ about, have you ever caught somebody not grounding? Have you ever disciplined somebody for not grounding? And all his answers were no. There's a kind of limitation there because he wasn't in a position to discipline for the entire time that he was like a foreman and then he moved to superintendent. There only came a point in time when he was in the position to discipline. But again, I would expect his crews not to have disciplines for something as material as not grounding when you're doing electrical work. That's like electrical 101, and these are IBEW journeymen. And there was testimony, Judge Coleman, about 3 non-grounding disciplines. And I know this because I tried this case. And I remember distinctly their expert, Dennis Bossy. Now, I can't locate it. I was trying to pour through this in the record, but I can't locate it right now. But I know if you look at the cross-examination of Dennis Bossy, he conceded that within his report, he acknowledged there were 3 instances. Now, they all occurred timely together where employees of the IBEW were disciplined for not grounding. So there were scant, and that's in our favor, I think, scant instances of disciplining employees for not grounding. And don't forget, when you're talking about the work environment at New River, it's a unionized environment. It's a lot different to discipline an employee effectively in a unionized environment when they're protected by that collective bargaining agreement than it is outside of it. That's not to say you don't do it, but it's a lot more difficult than it is when someone's employed at will.
Mr. Prytel, thank you for that. I'm going to go back and take a look at in Mr. Dossey's testimony. Do you recall of those 3 incidents, did they involve kind of proactive inspection, or was this post-accident, post-incident? Do you know?
I can't remember, Judge. I don't want to misspeak here. I can't remember.
That's okay. We can take a look at that.
I do remember the disciplines were severe for unionized environment. They were suspensions. These people were put on work off wages for a substantial period of time for not grounding, but I can't remember whether they were preemptive or as a result of an incident that occurred. I guess the one thing I haven't brought up and that I'd like to bring up in the argument is the whole way the administrative law judge limited what he was going to look at in terms of an effective safety program by saying, well, I'm going to only look at the electrical, the energetic electrical. Anything else is irrelevant in terms of the proactiveness we had in our safety program for a variety of things that are in our reply brief that have nothing to do with necessarily the electrical end of it. And there's a lot more driving, whatever it may be. There's a decision by the review commission called Dana Container, cited in our brief, where it's the opposite of what I'm arguing here, where when the government wants to cite an employer for a non-effective safety program, it says we have to look at things outside of what the particulars were to the citation. We're able to do that. So I guess my question is, why isn't the reverse true? Why isn't the reverse of having an effective safety program, we also look at all the things that the company did proactively and preemptively that occurred outside of mere electrical hazards or electrical events that occurred. It should be going both ways if that's the way you're going to analyze it. And we've argued that in our brief that Dana Container should apply here. You should have looked at everything, not just, hey, there was only 13 or 14 or 15 electrical related, incidents.
Priatel, you just so I understand that argument, are you saying that the company was ready, willing, and able to present that evidence, but it was foreclosed by the ALJ?
No, it's in the record, Judge. We weren't ready, willing, and able to do it. It's already in the record. The disciplines are in the record. He just refused to analyze them or look at them in the ambit of deciding whether we had a, quote, effective safety program.
Okay.
But they're in there. We weren't ready, willing. They were there. They were stipulated to as part of a pre-hearing stipulation that we had with the government. So they're in the record. I think the only other matter I want to mention, there's a case cited by the administrative law judge for the notion that twice a week safety audits in this Thomas Industry Coatings case that he cited. The review commission had rejected that as being sufficient. I went back and read that case, and I read it because I don't want to disparage any administrative law judge, but that in no shape or form did that in Thomas Industry Coatings case hold that, say that. I looked at the pinpoint site at star symbol 10 from the slip opinion citation, and he called it a review commission decision. It's an administrative law judge's decision. It wasn't from the review commission. It wasn't binding at all. What happened in that particular case is that particular employer had 3 tie-off fatalities where their employees were not wearing lanyards while working over bridge projects. And it not once changed its rules or practices or inspections during the course of those 3 fatalities. And for that reason, that administrative law judge says you don't have an effective safety program, but it had nothing to do with the number of inspections or whether twice a week was sufficient or insufficient. Unless the court has any further questions, we thank the court for its time and consideration of the case.
My colleagues have any additional questions?
No.
All right. Thank you very much, counsel, for your fine arguments this afternoon. The case is taken under advisement. We appreciate your being with us. As you may have heard from the earlier argument, it's our tradition to come down from the bench and personally greet you in this COVID world. We can't do that, but thank you nonetheless for being with us this afternoon, and be safe and be well. We'll move on to our next case, assuming that my colleagues are okay with that. You okay, Judge Thacker?
Yes.
Adams versus Robinson. And I'm afraid I may butcher this name, Mr. Houchin. Did I get that right?
That is right, Your Honor. It's Michael Houchin on behalf of the appellant.
Great. You may proceed.
May it please the court. This class action settlement presents a classic problem where the settling parties agreed to an overbroad release of the class claim in exchange for a red carpet treatment on attorney's fees. This was to the detriment of the class. In the case below, the plaintiff alleged that NationStar violated the Real Estate Settlement Procedures Act of the Maryland Consumer Protection Act with respect to plaintiffs and the class members' loss mitigation application.
I'm sorry, at least for me, could you speak up or closer to the mic or something?
Yes, Your Honor. Can you hear me better?
That is better. Thank you.
Okay. Loss mitigation is a process by which mortgage servicers allow borrowers to change the terms of their payment obligations in order to avoid foreclosure or delinquency. Prior to the settlement in this action, the district court ruled on NationStar's summary judgment motion and the plaintiff's class certification motion. Significantly, the district court granted summary judgment as to the plaintiff's wrongful disclosure and dual tracking claims. Dual tracking happens where the mortgage lender falsely leads the borrower to believe that it is processing a borrower's loan modification application instead of going through with the foreclosure process. The district court ruled that the plaintiff lacked standing to assert these dual tracking claims because, quote, NationStar had neither started foreclosure proceedings nor moved for foreclosure judgment on the Robinsons' home. The district court further stated, quote, the Robinsons admit they do not have evidence that NationStar dual tracked them or begin the foreclosure proceedings while a loan modification application was pending. And that's in the appendix at pages 108 through 109. Following this ruling from the district court, it basically allowed plaintiff Robinson to proceed on just 4 claims. The district court did certify a class of all persons in the United States that submitted a loss mitigation application to NationStar.
And did appellant opt out of the class?
No, she did not, Your Honor.
Okay, and how does that impact your argument here?
I believe in order to have standing to appeal, the objector shouldn't be required to opt out of the class. Instead, the proper procedure is through a written objection, and that's exactly what Objector McAdams did here. And so she raised the issues with the district court below, and that's why we're here today on appeal. So going back to the district court's class certification ruling, the district court expressly denied class certification with respect to the dual tracking claims. And that's at the appendix on page 137. Following the summary judgment order, the parties began to engage in settlement negotiations, and that resulted in the class action settlement that's subject to this appeal here today.
Mr. Halpin, could I ask you a question? You filed 28J supplemental authority from the Southern District of California related to the litigation out there. And as I understand it, in that particular case, at the motion to dismiss stage, NationStar argued the release barred Ms. McAdams's claims. And the district court denied the motion to dismiss, and in so doing, essentially ruled that the factual predicate, although there was some overlap between what the Robinsons had pursued in the Maryland litigation and what Ms. McAdams was pursuing under California law, and that they both applied for loss mitigation relief. The fact that Ms. McAdams had these dual tracking and foreclosure claims made them materially different, and he determined that the release didn't apply. So doesn't that pretty much undermine your argument that this release on its face was overbroad?
Yes, Your Honor. I think that's a correct summary of how the district court ruled in the Southern District of California litigation. The issue before that court was claim preclusion, and I think the issue before this court is whether the settlement is fair, reasonable, and adequate. And so I think this court needs to take a look at the identical factual predicate test as part of the fairness inquiry for approving a class action settlement. Several courts have held that that's the correct approach, and one of the courts is the Second Circuit, and that's the TBK Partners case that's cited in our brief.
Well, can I ask you just a quick follow-up? It seems to me that as the reviewing judge, the magistrate had to determine, with respect to overbreadth, is the release sufficiently tailored, right, to the facts that were raised by the representatives, the Robinsons. And in this case, kind of the core is this loss mitigation application process. The second thing that the district court, in this case the magistrate judge, couldn't do is predict the res judicata effect of the release, even though I believe your co-counsel asked him point blank at that hearing whether or not he believed the release would bar the claims in California. That's improper. That's essentially rendering an advisory opinion. So I'm trying to understand where the magistrate judge got off track, given that there's enough factual similarity and he can't predict a res judicata effect.
Yes, Your Honor. So I think if you just take a look at the release in the settlement itself, it says that it releases every claim that were or could have been asserted by the class representative or the class members in connection with the submission of loss mitigation applications during the class period. And so that in connection with language is really important because in order to have dual tracking claims, it necessarily follows that a borrower would have to submit a loss mitigation application. So I think it should have been obvious to the district court that this settlement would preclude claims like the dual tracking claims and the wrongful foreclosure claims. And that's exactly what we brought up at the final approval hearing. And so I think other district courts have really
Mr. Halchin, can I just follow up on Judge Cullen's claim? You say it should have been obvious to the magistrate judge, but a district court judge in California has essentially said that it wasn't obvious by virtue of the fact that it decided to allow your client to proceed with these dual tracking claims in California.
That's correct, Your Honor. And I just go back to the release language. I think the magistrate judge in the case below was required to look at the release language in determining whether the settlement's fair, reasonable, and adequate. And several district courts have done such an analysis. One example is the Marshall versus Northrop Grumman case that's cited in our reply brief. That case kind of involved a similar type of release language that it says in connection with the claims. The court there denied preliminary approval based on an overbroad release. And page 11 of our reply brief cites additional district court cases where the district court essentially look at the scope of the release language in determining whether the settlement's fair, reasonable, and adequate.
Can I ask a question? So were you prepared at the hearing? I don't think this came up, but or if it did, maybe you can correct me. Did you have alternative language that you would have proposed to the magistrate judge with respect to how to limit this agreement?
No, Your Honor. During the hearing, we didn't propose any alternative language, and I think that's one thing that's important here is that the settlement must stand or fall based on the terms of the settlement agreement itself. So I don't think the magistrate judge would have been in a position to really rewrite the settlement agreement on behalf of the parties. I think that would have been something that would have been negotiated separately, and they would have needed a revised class action settlement agreement. So despite our concerns with the overbroad release language, the magistrate judge below still found that it was based on an identical factual predicate. We obviously disagree with that because it includes these wrongful foreclosure and dual tracking claims. And, these claims have value. Under the terms of the settlement, there was something like 48,000 class members who submitted claims. And with the pro rata distribution, it comes out to class members will receive approximately $29. This is woefully inadequate for these types of dual tracking claims and wrongful foreclosure claims. For example, the California Homeowners Bill of Rights statute that Ms. McAdams asserted in her California case, that statute provides significant statutory damages in the amount of $50,000 for these dual tracking claims if the plaintiff can prove that it's intentional or reckless. So these claims have great value, and I think the scope of the release includes these claims, and not just the dual tracking or foreclosure claims, but potentially other claims that could arise under RESPA. And so we think that in connection with loss mitigation application language is very problematic here. I'd also like to address the district court's opinion in general, approving the settlement as fair, reasonable, and adequate. I think one thing that the district court missed here is really the analysis of the factors that are required by this court under the Lumber Liquidators case and the Enri Jiffy Lube case. The court cited the factors in its final approval order, but really didn't conduct a thorough analysis of the factors. Really, one of the main factors under the Lumber Liquidators case is the solvency of the defendant and the likelihood of recovery on a litigated judgment. The district court really made no findings of what the amount would be to the class if this case were litigated all the way to a final judgment.
Mr. Houchin, can I ask you this? I would agree that perhaps the order on its face was a little thin, but in terms of the judgment, don't we have to consider what the magistrate said at the approval hearing itself, and specifically pages 811 through 818? He went into very specific detail using the factors that he had to consider under Fourth Circuit precedent in terms of substantive adequacy. I mean, he noted, and this is huge, that the $3 million settlement fund was 3 times the statutory cap on class actions for RESPA claims. He also went through the history of the litigation, the risks associated with potentially the class would be decertified, and among others, that only one out of, 348,000, 0.003% objected. So in other words, that's a long question, but don't we have to look at what he articulated at that hearing in addition to the proposed order that he essentially adopted?
Yes, Your Honor. I think it's fair to say that you can consider what the district court said during the final approval hearing. One thing, though, with the lumber
and in the final order, at JA 831, the district court incorporated its previous conclusions about the fairness of the settlement and the adequacy and reasonableness of the settlement in its preliminary order. All of that is incorporated into this final order.
Yes, I would agree with that also, Your Honor. If you look at the preliminary approval order, it's also kind of scarce in its analysis of the factors. And I see I'm kind of running over my time, but I can proceed.
You can respond to the 2 questions that were posed to you. Go ahead.
So even during the final approval hearing, the court really didn't analyze one factor that it's supposed to consider under the lumber liquidators case, and that's the likelihood of recovery on a liquidated judgment. The district court did talk about the statutory damages that are available under RESPA, but RESPA also allows for actual damages. And, the plaintiffs in this case were alleging, $141,000 in interest.
I don't know about Judge Cullen, but that answered my question.
Thank you, Your Honor. I'll save the remaining amount of my time for rebuttal then.
Thank you, Mr. Houchin. Mr. Tyko?
Now it's Tico, Your Honor, but may it please the court. I am
sorry
Jonathan.
about that.
No, it's no problem. Everybody does it. My name is Jonathan Tico, and I represent the plaintiff, and my firm was also appointed as counsel for the class in the court below. So I'll start with the release question. The objector and the amicus brief that was filed in this case as well take the position that this settlement is of great concern because it precludes a host of valuable wrongful discharge claims that could be brought by class members. The problem with that argument is that it's a misinterpretation of the settlement agreement. The settlement agreement simply does not do that. For one thing, the release language of the settlement agreement releases only claims, not defenses. So there's nothing in the settlement agreement that would preclude anybody from defending against a wrongful foreclosure action by claiming that they had been dual tracked. But most importantly is that the settlement agreement was negotiated to include limiting language in the release. The only claims that are released are those that are in connection with the submission of a loss mitigation application. And a loss mitigation application, that is a technical term under the CFPB regulations. And those regulations are not about substantive rights. They're about timing and notices that a servicer has to provide to a homeowner that applies for loss mitigation through a loss mitigation application. Even the dual tracking provisions of 1024.41 are procedural and primarily about timing. They do not provide any substantive right to receive loss mitigation on behalf of the borrower, and they do not alter the lender's substantive rights under the loan documents. So the the question of whether or not a claim for damages for violation of the dual tracking provisions of the regulation is covered by the release was appropriately handled by the magistrate judge who approved this settlement. He clearly took into account the identical factual predicate standard. He said in both his oral ruling and in his written ruling that he was aware of that standard and was applying that standard. So he applied the appropriate legal standard. And he concluded that the language that the parties had negotiated was sufficiently tailored to the facts of the particular case. And how that language would be applied to claims of absent class members was something that he also, I think, correctly and appropriately declined to offer an advisory opinion on. And as we can see from what happened in Ms. McAdams' case against Nation Star in California, the courts in those subsequent cases will apply the law correctly as well. And in that case concluded that Ms. McAdams' dual tracking claims were not covered by the release.
Counsel, can I ask a question about the scope of the release and how we're supposed to test it? I mean, it can't be the case that in every situation when an objection is made to a settlement agreement, it comes up on appeal. The answer is, well, we'll look to see how subsequent district courts analyze the settlement, right? Because that can't be right. So what is the appropriate test?
Right. I think that really gets to the heart of this question, Judge. And the appropriate test is the identical factual predicate standard. But that standard gets applied both in our case at the approval stage, and it could also be applied in the subsequent cases. But the difference is that in our case at the settlement approval stage, what the judge is being asked to do is to look at the language of the settlement that the parties have negotiated and make a determination about whether that language is appropriately tailored to the facts of the case. They're not being asked to consider all of the theoretical potential claims that other class members might bring in the future. That is what the courts applying the standard in the subsequent cases do. They look at the actual facts of that subsequent case, for example, Ms. McAdams' case, right? And they determine whether or not on those facts, that case should be considered to have been released.
One of the concerns, sorry, Mr. Patico, one of the concerns that Mr. Houchin raised, was the phrase "in connection with," which he fears is just simply too broad, sweeps in a huge number of cases that aren't appropriately part of the settlement. And he cited to a number of district court cases that he referenced in his reply brief where courts have agreed with him, he says. Why is this case different?
Well, I think most of those decisions, Your Honor, if you look at them, were actually subsequent court decisions. They were not necessarily the court that was considering the fairness of the settlement agreement per se. So there will always be the theoretical possibility that a release is going to have some gray areas that are going to have to be resolved in those subsequent cases if the release is asserted by the defendant as a defense in those cases. There's never going to be a perfect sort of one-to-one match. So I think what Magistrate Judge Sullivan did in our case was what he is supposed to do, which is to look at the language of the release and say, is that language sufficiently tailored? And here, the language that we put in the release was connected to loss mitigation applications. Again, loss mitigation applications, connected is a broad word, but loss mitigation applications is a very narrow word. So they do have to be connected to the actual applications, not to other things that a loan that Nation Star is doing as the servicer of the loan. It has to only be connected to the Nation Star's handling of the loss mitigation applications. Now, this is abuse of discretion review. I mean, certainly in retrospect, perfect hindsight, you could always say, well, you could have written the release differently. But that isn't really the question. The question is, did Magistrate Judge Sullivan, was it within his discretion to look at this language that the parties had negotiated and say, in the context of this settlement, this is sufficiently tailored?
Ms. Pico, could I jump to another argument? I want to give Mr. Houchin a chance to address it as well. But essentially, they make two arguments with respect to the magistrate judge presiding at all, right? There's this kind of threshold jurisdictional argument, 636, Ms. McAdams did not consent. That's not necessarily my concern. It's the second argument that this magistrate judge, who was very involved in negotiating, at least the money, I think is how he described it, to bring about this settlement, had essentially a conflict of interest. So two questions on that. One is, as I understand it, that argument was not raised either in writing or at the fairness hearing. So I think there potentially is a waiver here. But set that aside. Isn't that a valid concern when you have a magistrate judge who is very involved in the negotiations, then put on a different hat to approve a settlement when you have this fiduciary obligation to make sure that the unrepresented class members are protected?
Well, you're right that issue was waived. And I would just add to that, there's nothing in the rules or case law that anybody has pointed to that would suggest that what Magistrate Judge Sullivan did was improper, or that what Judge Schwang did in delegating the case to Magistrate Judge Sullivan was improper. So we would be creating essentially a new rule in a case where the issue was waived. But having said that, I mean, certainly my experience in the trial courts is that judges often play some role in helping the parties towards settlement. I don't see how you would say that a judge who does that has a quote unquote interest in the settlement. I mean, they're not a party to the case. They're not going to benefit from the settlement one way or the other. And I think if you created a rule that said any judge that had some involvement in helping the parties negotiate towards a settlement is therefore precluded, that would kind of unnecessarily intrude into the workings of the district court, where this happens quite frequently in my experience.
Well, so just one final point on that. I mean, I think there's a difference in my limited experience, encouraging the parties to go see the magistrate judge to undertake negotiations towards a settlement. That's one thing. But to actually be involved kind of in the day-to-day nuts and bolts, and I think one of the concerns is ex parte communications, is something else. And I'm not sure, and I agree with, there's no doctrine on this whatsoever, and I don't think they kind of articulated a standard for us, and it may be way, but it is an interesting issue, and it's one that gave me pause.
Yes, I understand. Would it be okay if I had 30 seconds to just address one issue, Your Honor?
Go ahead.
And this is the question of standing. So particularly in the amicus brief, but also in the objector's brief, they make the argument that Mr. Robinson did not have standing to pursue claims other than the ones that survived summary judgment. And that comes from language that was in Judge Schwang's summary judgment and class certification ruling. And that ruling is not before this court, and the court doesn't need to decide the issue of standing. But I just want to say that Judge Schwang made an analytical mistake there. That is not a question of standing. The court had Article III standing. The appropriate standard for determining the scope of the claims that can be handled by a class representative is not standing, and it's not a claim-by-claim determination. Instead, you just look to the Rule 26A factors, particularly commonality and typicality. This court made that exact point recently in the Mayor of Baltimore versus Actelion Pharmaceuticals case. And so I would just urge the court, in writing your opinion, to not inadvertently give an imprimatur to that particular part of Judge Schwang's analysis. Thank you.
Thank you, Mr. Tico. Mr. Kemp?
Yes, good afternoon, Your Honors. Eric Kemp for Nation Star Mortgage, and may it please the court. I will also start with the release issue. I think the parties agree on the underlying legal standard, which is that it's okay for a release in a class action settlement to cover unalleged claims so long as they are based on the same underlying factual predicate. And so the question here is whether the release is overbroad because it covers claims that don't arise from the same factual predicate. And we believe the answer to that question is no. The underlying case concerned various alleged flaws in processing loss mitigation applications, including failure to acknowledge receipt or decide them in a timely fashion, or devise of appeal rights, failure or requesting duplicative information, and failing to respond to complaints or inquiries. The release in this case is consistent with those allegations in that it applies only to claims that are related to loss mitigation applications and that were or could have been asserted in this action. And by tying the release with that language, the class release is appropriately limited to claims that rise out of the same factual predicate. I think it's very similar to the release language in the Dobie Deja Vu case from the Sixth Circuit. And that's exactly how the district court interpreted the release in this case. In the order, which is at JA 835, finds that the release is narrowly tailored and limited to claims pled or that could have been pled based on the facts alleged in the complaint. Ms. McAdams' argument focuses heavily on one fact, whether a borrower's property was foreclosed, and is effectively arguing that there's some sort of blanket rule that if there's a foreclosure, the claims can't be covered by the settlement. And that can't be correct. Whether a borrower's claim is barred by this settlement turns on the specific facts underlying the claim that she might pursue against NationStar, not whether or not there happened to be a foreclosure. So if the claim is based on the submission of a loss mitigation application and it arises from the same factual predicate, it is barred regardless of whether or not there's a foreclosure. But if it arises from a completely different factual predicate, for example, the borrower to say that I was never in default in the first place, or NationStar didn't give me sufficient time before the foreclosure took place under state law, those sort of claims clearly aren't barred. And I think that the recent result in the McAdams case in the Southern District of California illustrates this point. We took the position that the claims did arise from the same factual predicate, though Ms. McAdams has a dual tracking claim. In our view, that loan actually was not dual tracked. And so in that sense, it is very similar to the Robinson situation where you have the claim alleged, but we don't think there are facts that support it. The district court disagreed with that and found that the claim could proceed, that it didn't arise from the same factual predicate. And that's entirely consistent with what we've been arguing in our briefs, that it's for the McAdams court to determine the effect of the settlement on the claims asserted in that case. And any other class member, I mean, it's notable that there's only one substantive objection out of over 340,000 class members. But to the extent there's anyone else out there who would make the same argument as Ms. McAdams, her experience demonstrates there's a procedure for them to argue that their claims are in fact not covered by the release.
Mr. Kemp, can I ask, so the whole purpose of the class action, though, is to incentivize or at least allow for individual claims to be brought together as a class, because otherwise the incentives aren't there to do so individually. And so I don't know that it's a good response to say, well, these class members can decide to litigate separately claims that they feel fall outside of the settlement agreement. I mean, that's the whole reason why you have a class action.
Yes, Your Honor, and I think as Mr. Tico said, the court certainly has to review the language of the release in this case and ensure that it arises, that it's limited to claims asserted under the same factual predicate under the abuse of discretion standard. And I think that the magistrate did that in this case by expressly finding that the release was limited to claims that were or could have been asserted in the action. Releases are forward-looking in nature, and it's difficult to describe, particularly in a case like this with many different violations asserted. It's difficult to describe or anticipate every sort of permutation that might arise in a future case. So what we tried to do was to describe the core issue, the submission of the loss mitigation application, which is a defined term under the RESPA regulations, and limit it to claims based on that were or could have been asserted in the action. I would also note that the release in this case is limited in temporal scope. It applies only to claims between January 2014 and September 2019. Practically speaking, to the extent there are issues about loss mitigation applications that any class members have, many of them have already likely been addressed by the courts or otherwise. I also wanted to briefly address Mr. Houchin's comments about the district court's consideration of the Jiffy Lube factors in approving the settlement as fair, reasonable, and adequate. The primary argument appears to be that the district court didn't go far enough in trying to estimate the amount of class members' individual claims or damage awards. But I think it's notable that this court has never held that that's required under Jiffy Lube or any other case. And given the nature of the claims in this case, it would have been extraordinarily difficult for the district court to make that sort of calculation. For example, on our summary judgment motion, while it's true that the Robinsons claimed about $140,000 in damages, the district court found many of the types of damage they claimed unsubstantiated. One area where he found a triable issue was where there was postage costs incurred for the various communications back and forth with NationStar. That sort of damage is highly individual and is going to vary from borrower to borrower. So this is not like a wage and hour case where you can just tally up the hours or time that was uncompensated and do a simple equation and determine what each class member's recovery would be. It'd be a highly individual inquiry where it's basically impossible to do what Mr. Houchin was asking for. So we don't think the district court abused its discretion in not doing a further analysis of the class claims on that issue. Unless there are further questions for me, I believe I'm prepared to submit.
Thank you, Mr. Kemp. Mr. Houchin, you've got some time for rebuttal.
Thank you, Your Honor. Just going back to the scope of the release, this presents problems because there's really two issues, an issue of standing and an issue of adequacy of representation. So Plaintiff Robinson never had standing to assert the dual tracking claims. And under the recent opinion in the Murawski versus Godiva chocolatier case in the 11th Circuit, that court found that a class action settlement can't release the claims if the named plaintiff doesn't have standing to assert them. And that's essentially what happened here. I mean, the release language can be read to encompass dual tracking claims. NationStar argued that the release would preclude Ms. McAdams' dual tracking claims. But I think this court really needs to look at the standing issue as to whether Mr. Robinson even had standing in the first place to assert those claims and release those claims, which we don't believe he did. The second issue is the issue of adequacy, whether Mr. Robinson was an adequate representative of the class. And as the court in the McAdams case in California found, that wasn't the case. He never had dual tracking claims, so he didn't prosecute those claims vigorously on behalf of the class.
Well, Mr. Houchin, let me ask you about that. So with respect to adequacy of representation, that's an issue that has come and gone by the time you get to the settlement, the question of the fairness hearing, isn't it?
I don't believe so, Your Honor. I think under the amended rules 23E2, district courts are specifically supposed to look at whether the class representatives and class counsel have adequately represented the class. And I think with respect to that rule, you have to look at what type of class claims are being released. And so adequacy came up earlier during the class certification ruling, but then the release under the settlement purports to release claims that go outside the scope of the claims that the district court allowed to proceed. And so I think
let me take it back to this issue of standing, because Mr. Tico mentioned this, and I want to be sure I understand your position. So clearly, Mr. Robinson had standing to assert claims. I mean, he may not have been on all fours with every possible claim that each individual class representative might conceivably have, but that's not, I don't believe, the test for standing, is it?
I would agree with you, Your Honor, that he certainly had standing to assert some claims, such as the claims that the district court allowed to proceed, such as the delay in processing the loss mitigation application. But he didn't have standing to assert the dual tracking claims. And so
I don't understand that. You either have standing or you don't. I mean, it's a separate question of whether or not he has so little in common with the class that he may not be an adequate representative. But once you get past the issue of whether he had standing to assert the claims, then we're into adequacy, which is a separate issue.
Yes, I agree with that, Your Honor. So I don't dispute that he had standing to assert some claims. It's just the dual tracking claims he could not assert because they were dismissed at the summary judgment stage. And so I think it goes into adequacy as well. He was not an adequate class representative as far as the dual tracking claims go, because he couldn't assert those claims in the first place. So
can I ask you a question that Mr. Kemp brought up in his argument about, and I think you raised this initially in your initial argument about calculating or estimating damages. It's true, I think you would agree that our cases don't absolutely require that in each and every case, and that would frankly be impractical. So the question here is this one of these cases where it simply would have been difficult, if not well nigh impossible to do?
I think the parties were at least required to provide a rough estimate of what the actual damages were, and that's something that they didn't do in this case. I mean, Rule 23E2 asked the court to consider whether the settlement is adequate. You have to consider what the likelihood would be on a litigated judgment in order to make that adequacy inquiry. And I think that's really one of the Jiffy Lube factors, the solvency of the defendant and the likelihood of recovery on a litigated judgment. So I don't think that either the parties or the district court really gave a ballpark estimate of what the actual damages would be here. And I think that's required under the rule. I'd like to just address one issue that Judge Cullen raised earlier with respect to the magistrate judge presiding over the settlement proceedings. There was an issue of waiver as to whether Ms. McAdams waived that argument. I'd just like to point the court to the appendix of pages 792 through 795. Those are pages of the reporter's transcript from the final approval hearing. During the hearing, we did object to the magistrate judge proceedings, so we don't think that argument's waived here.
But as I understand that, Mr. Housens, that objection related to the 636 and Ms. McAdams not consenting to the magistrate judge's jurisdiction. That's the way I read that, not that you are raising an issue with respect to essentially a conflict of interest, the appearance of a conflict of interest. Am I misreading that?
Yes, Your Honor. I think we brought up the issue that the magistrate judge was also the judge who essentially mediated this case. So I think that was brought up during the fairness hearing. I think you're correct that it was the 636, but I don't think we waived that argument, and it was brought up during the final approval hearing.
All right, and I just want to close a loop on this. It's 793 at the top. With all due respect, Ms. McAdams does not provide her consent to proceed before the magistrate or a magistrate. So I read that as Ms. McAdams is objecting to the magistrate judge presiding under 636. I don't read that the magistrate judge has some conflict and can't approve the settlement. But I understand your point.
And I don't see a conflict argument anywhere in your opening brief.
Yes, Your Honor. I think that was raised in the opening brief towards the last pages there, where we argued whether the magistrate judge has jurisdiction. I see I'm going over my
Jurisdiction,
time.
yes.
I'm sorry, Your Honor.
Yes, you did raise the jurisdiction issue.
Yes, and I think we brought up the conflict issue. And like Judge Cullen said, there's really no set standard on that issue. The Kobe Court in the Ninth Circuit left that as an open question, but we haven't been able to find any cases that really deal with whether there's a conflict of interest when the magistrate bench presides or mediates the settlement.
All right, thank you very much, Mr. Houchin. The case has been submitted. We appreciate your arguments, and would, as I mentioned earlier, typically come down from the bench to greet you personally, but obviously we cannot do that. But thank you all again for your arguments here this afternoon. We really appreciate it and hope to see you soon. Take care. I'd ask the court clerk to adjourn the court until tomorrow morning.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Judges, I'm going to put you in the virtual roving room. Just give me